gonna get hot, so cups up, everybody.
Cups up.
Cups up.
Good to see y'all.
The settlement that happened on Monday between J.P. Miller and Mica Miller's family, the Francis family. And this case was in family court and probate court. And it was sort of a global settlement where they're not going to have a wrongful death claim on either side. A lot of people were upset about this. And I think they saw it as, you know, maybe the Francis family giving up or maybe a win for JP. And I know that you, as an attorney, you have to go by what your client wants, right? And so I know there are times when you have to settle a case that you know you can fight and win, but it's sort of the better thing to settle a case, right, psychologically. If you could just talk about that, because I think that
let me explain how it works. Our job is to be competent and keep a client fully informed. So to be competent is the first thing. We have to understand the case. And understanding the case, you have to understand the positives and the negatives. You have to understand the emotional toll that it would take on your client to go forward with litigation. Even if you can win, you have to understand how long it'll take, and then the legal issues that could be an impediment to your claim, because factually, all the time you think, well, this is going to be easy to vindicate or prove, but the law tends to be difficult at times and stands in the way and as an obstacle to a successful recovery. So that is the first thing to be competent. The second thing is informing your client. And you inform the clients of both the benefits and the risk, how long it'll take a case to go through, what will be the cost, because ultimately the costs go to the client. Even if I take a case on a contingency, I'll advance the cost, but under any settlement, the cost will be taken from a recovery. So fast quarters now may be better than slow dollars 5 years from now.
The thing about that press conference, that where it got out of control, is when Russell's Be Wrong started shaming people for protesting the churchgoers. And the churchgoers that are still going to Solid Rock and are still supporting JP, they deserve every bit of scrutiny that is coming to them. Because Liz and I were talking about this the other day. The enablers are who really empower a bad person. The enabler, the people, the circle around them are the ones that are at fault for making the monster and for propping the monster up. And JP is never going to change his ways as long as he has supporters by his side and as long as he doesn't have to admit to anything. And that's another problem.
And there are no repercussions.
And there's no repercussions, right? He is losing churchgoers. He's losing money from this whole thing. That is very obvious from everything that he has said so far. He always mentions the fact that he is the one suffering because he's lost churchgoers and he's lost money. He does not say if that's because of his own actions, but it is. People have finally seen him for who he was. And I also believe that he's coercively controlled a lot of people in that church for a long time who were not able to see exactly what was going on until Mica's death. And I think that he preyed on vulnerable people. I think that he sought out vulnerable people to attend his church, and people specifically who would be yes men surrounding him. And I have a real problem with Russell Be Wrong standing up there just shaming people who are protesting those churchgoers because they are enablers. And speaking of men who believe that they can talk their way out of everything and don't give up.
A bear trap.
Alex Murdaugh's appeal in federal court, the date has been set. Am I saying that right, Liz?
Yeah, so there's a date set for the hearing in Richmond, Virginia, and then his team asked for an extension. They have to file, obviously, what their position is going to be. So they got their date before they put in their briefs, which I don't think worked the same way with Russell Lafitte. And their filing is due now on August 8th. It was due on August 1st. And this isn't something that's going to take days. This isn't something that even is necessarily going to be a real crowd catcher. And again, there's no cameras in federal court. But have you been to Richmond?
I have. I've argued It's very, it's intimidating. You know, the judges sit high, very much higher than where you're sitting at the table. And, you know, depending on if it's an activist judge who, you know, you have your argument, you have it that you can formulate it in 15 minutes, and you don't sometimes get the words out of your mouth. My name is Eric Bland. I represent the appellant. And then, Mr. Bland, let me ask you this question. And you don't even have a chance to get to your argument. You're sitting there fielding questions, and you could tell by the questions that are being asked what they're interested in. And you could tell if you're getting hammered more than the state. And you got to try to collect your thoughts, because they asked you a question that may be something that you would get to in minute 10 to 15. Now you got to try to backtrack. And it's really unnerving because you don't control it. It's not like a judge will let you go and you can make your argument. They interrupt, and they ask some very pointed questions.
I'm just giggling to myself because I do not think that this is Dick or Jim's strong suit.